My name is and I'm the spokesperson for the Public Protector, and I shall be chairing this afternoon session. I'll start by introducing the panel. Next to me is the Public Protector Advocate Thuli Madonsela, and next to the Public Protector is our new Chief Executive Officer Advocate Louisa Zondo. And on my extreme left is our new Chief of Staff, Mr. Bonikosi Dlamini. I'd like to welcome you to our media briefing for the 2016-2017 financial year. And I would like you to observe the following house rules. We shall afford you the Q&A opportunity at the end of the address by the Public Protector. And as usual, we will ask you to introduce yourselves before you ask the question, and also tell us the media house that you represent. And as usual, we ask that you put your cell phones on silent, and we will also be able to provide you with copies of the report that the Public Protector is releasing this afternoon. And on that note, I will hand over to the Public Protector to address you. Thank you.
Thank you, ladies and gentlemen. We appreciate you being here, and we apologize for starting a little late. Please allow us to give a minute or two to our new Chief Executive Officer to greet you and perhaps extend a message or two.
Thank you very much, Public Protector. And ladies and gentlemen of the media, you're very welcome to the Public Protector House. I, of course, am very, very new in office, but I do look forward to the continued participation of this institution in the strengthening of our constitutional democracy, and I hope to be a very active part of the support which not only this institution gives in that regard, but that the whole South African public give to the strengthening of our constitutional democracy. Thank you very much.
Thank you, Advocate Zondo. Many of you will recall that she was the first Chief Executive Officer of the Human Rights Commission when it was established in 1996, and has since had an illustrious career that includes being a Chief Executive Officer in a global organization. Dear colleagues, we should be releasing 2 reports today from the Public Protector South Africa team that have been postponed to the 3rd. Both reports that have been postponed are reports that are dealing with whistleblowers, and both of them are complete and sitting on my desk. However, we discovered in the process of finalizing the release process that those 2 reports had not been served on 2 people that were crucial in respect of each. One relates to a whistleblower case at the Treasury in the KwaZulu-Natal government. The other one deals with an old whistleblower case at the Estate Agent Board. Please bear with us that we've had to defer them. However, they will definitely be released on the 3rd as soon as we've received responses to the notices that we've served on those 2 people and integrated and evaluated. answers. As you're aware, the media briefing was initially planned to take place 2 weeks ago. Again, it was postponed. You ask yourselves, why these days are we postponing our media briefings? We have 28 cases in courts where we're being reviewed. And one of the areas of attack are people saying they were not sufficiently consulted, or even when they were consulted and given all of the paperwork, they say they were not given adequate time. And that's the case, for example, with the KwaZulu-Natal one. The one person was honestly not given a notice before last week. The other person was given notices. We met with her, but she has been insisting that she hasn't been given adequate time, and because of avoiding a legitimate review, we have extended the timeline for them to comment, and are then prepared to release those reports on the 3rd of October this year, which is Monday, a week from now. Today marks exactly 14 days before the end of my non-renewable 7-year term of office, and naturally my team and I are racing against time to finalize several matters that the people of South Africa have entrusted us with. Contrary to popular belief, the workload that remains to be dealt with in the next 2 weeks is a mixed bag of cases that involve ordinary people as well as the so-called high-profile cases. Some of the matters that we are racing against time to finalize include a systemic investigation on the RDP program. You'll recall that we released an interim report and indicated that a final report will be provided. We also released an interim report on Millennium Development Goals, where we were doing a systemic investigation focusing on health and poverty. We're now finalizing the final report. We also conducted a systemic investigation on illegal conversion of panel burns. That too is being finalized. Pelindaba nuclear matter is in the process of finalization, as we have seen in the media. We're finalizing the Mandela funeral report. We're finalizing a report that is called CX, which is a report involving the conduct of the first democratic government when it received a report from an organization called CX. We are finalizing Hlasela 2, Prasa 2, Freddy Dairy Farm. We also have reports that are not being finalized, that are in the process of being dealt with, and one of those deals with allegations of impropriety, including corruption at SASA. Lastly, we are also in the process of finalizing a report into alleged state capture. All these investigations, we have some high-level drafts that are being cleared up and quality assured, and we're hopeful that we will meet our deadline. We welcome the curious but belated interest in one of these investigations, the so-called CX matter, which somehow has been connected to state capture. As you may recall, it's an old investigation that only 2 journalists had an interest in, until we started the new state capture investigation. In which case, every time this investigation is being mentioned, it is linked to the concept of state capture. But just to clarify on that investigation, we're not investigating what happened during apartheid. We have no authority to do that. And anybody who had an interest in any event had 22 years of democracy to look into that. What we voluntarily chose to do in exercising the discretionary powers of the power protector was to review the conduct of the government of President Mandela on receipt of a so-called CX report. And we're just looking into whether or not that conduct was proper, as envisaged in Section 182 of the Constitution, or could constitute maladministration. As you know, the government had commissioned an investigation into CX. It had commissioned an investigation which was to be conducted by a company called CX, which is headed by a former member of the UK MI5, which is the equivalent of the CIA and the equivalent of our state security agency. We have made headway in that investigation and have interviewed virtually everyone that needed to be interviewed. An advanced draft of a report is being quality assured, as many other reports are currently being quality assured. In regard to this one, I do recall that there is one outstanding interview that still needs to be conducted. We are aware of unfounded allegations that I'm reluctant to investigate the matter. To these people who have recently gained interest in this matter, they just need to know that if I didn't want to investigate this matter, I wouldn't have, because there's no law that forces me to investigate any matter. It's discretionary power, which is exercised after a thorough triaging process, and sometimes after a toing and froing process, as it happened in this case. When I eventually decided to investigate this matter, it was because I thought there was reason to investigate it, and once we've decided to investigate a matter, we investigate it. In any event, if we didn't want to investigate it to conclusion, we still had another opportunity to issue a closing report, which by now we would have issued that closing report if we had no interest in this. So these newfound gurus who have more interest in this matter than we do have are really false prophets. Firstly, they were there when this thing happened. Secondly, when Paul Hoffman initiated this investigation, they were not there to support it. And suddenly, their whole lives seem to depend on this matter. We wonder why. Another investigation that has been topical in the media is the so-called state capture investigation. Again, I want to clarify to those who have decided that this is now a ground for mudslinging, calling me an agent of white capital and all sorts of things, that I did not initiate this investigation. This investigation was initiated by a collective of Catholic priests of the Dominican order, who alleged that the president had improperly allowed a particular family to influence the appointment of ministers in government and the appointment of members of boards or state-owned enterprises. and that this family and its companies were using undue influence to control tenders or to get themselves awarded tenders and to get undue payments to them. There was also an allegation that this family and its particular companies were being favored in licensing through organs of state. I had discretion to investigate or not to investigate. And whilst we're still considering whether or not to exercise that discretion favorably, another complainant filed a complaint. And the complainant that filed that complaint was a member of parliament who filed that complaint in terms of the Executive Members Ethics Act. And as you may recall, ladies and gentlemen, a complaint that is properly filed or properly lodged under the Executive Members Ethics Act does not give me discretionary power to say yes or no. If a complaint is filed in terms of the Executive Members Ethics Act, I must investigate. It was for that reason that I chose to investigate and duly requested resources from government and was given at least half of the resources that were requested. We requested 3 million, we were given 1.5, and it was said that should we need more, we may have to come back and make a report. We wanted to just clarify that I don't sit in a little corner and decide who or what to investigate. It's members of the public who are concerned about good governance that lodge these complaints. It is members of the Public Protector team in the intake and assessment unit within our complaints and stakeholder management branch that sit and go through these complaints and decide, do we have jurisdiction? And if we do have jurisdiction, should we exercise it favorably in terms of our discretionary power? Having been duly advised by that team, I then decide whether or not to proceed. But if it's an Executive Members Ethics Act matter, I have no option but to investigate. This brings me to the issue of, are we prioritizing any investigation? As some of these people that have started to accuse me of all manner of things have done. No, this investigation was assigned a particular team, and there are other teams that are conducting other investigations. And at the beginning of this month, I requested the Chief Executive Officer to work with the team to identify other reports that need additional resources and to make sure that all of those investigations are resourced so that reports could be issued. In other words, we are not conducting any investigation at the expense of what we refer to as Gogo Dlamini cases. Indeed, the case that I'm going to report about today could easily be classified as a Gogo Dlamini matter. But just before I go into it, I thought I should address one thing. You probably are going to ask about it. These people that have just decided that they want to attack me from all corners have suddenly found an interest in my association with the South African Jewish Board of Deputies. Interestingly, they are aware that I've been dealing with the South African Jewish Board of Deputies for the last 7 years. In fact, the highlight of that relationship was last year when the South African Jewish Board of Deputies awarded me the Shivas Award in honor of Chief Rabbi Harris. And there was no problem. Nobody complained about it. And they went yesterday and issued a statement. Incidentally, after one of them inquired in my office about what was I doing in Durban, but didn't bother to collect the information properly. I'm now being accused of having fundraised for Israel. Just an honest assessment of the event and an honest assessment of my invitation, which some of the people accusing me of that had access to, would have clearly clarified that the event had nothing to do with supporting Israel. The event was called to fundraise for an old age home in Durban. And they presented slides on the old age home, the current condition of the old age home, and testimonials from residents of the old age home, and indicated exactly what they wanted to do with the money, which was renovation at the center. But secondly, the invitation to the pub protector was very clear, and we issued a media statement regarding that invitation, as we normally do. Clearly indicated that I will speak on the powers of the pub protector, and the role of the pub protector, and how can the public work with the pub protector to protect the people. And that's all I spoke about. Now, the Constitution is very clear that the pub protector must be accessible to all persons and communities. There is no provision in that Constitution to those who are attacking me that says no Jews allowed. There's no provision in the Constitution that says if you are a friend of Israel, the pub protector must not be accessible to you. So good people, can we stop playing these games? It happens a lot when there's an investigation that people are not happy about, that people start lighting a fire behind my back. And we've seen people going to police stations accusing me of being a spy. I'm now being accused of being a supporter of Israel. For goodness sake. Firstly, I'm on record as supporting a two-state solution for Palestine. I'm on record as having spoken about the need for justice for everyone, for social justice in Palestine. I'm now being accused of endorsing what the Israeli ambassador said when he said it's important that Israel allows dialogue. What could be wrong with that statement? Because the ambassador was right, that the solution to the problems that we see in the Middle East and here in this country is dialogue, honest dialogue, and a commitment to social justice. And yes, I endorsed those views of the ambassador. I have no problems with Israel. If people have problems with Israel, that's their constitutional right to have. For me, all I'm interested in is justice for all, a peaceful world. That includes a peaceful world and a just world for both Palestinians and Israelis. We all have a right to have a particular view of the world, but please, good people, don't impose it on me. Not as a pub protector, not as a person, because as a pub protector, I am required to take a neutral stand. I can't have a sign on this building that says no Jews allowed, no friends of Israel allowed. However, I need to clear that because the schizophrenia that is taking place around all manner of accusations is trying to really distract me and my team from our work. Well, let those who are responsible know that we will not be distracted. We can't be distracted. We are employed to do our work, and our work we will continue to do. without fear, favor, or prejudice. Lastly, if anyone is worried about anything, whoever you are, I give you my word. If you didn't do anything wrong, the report will vindicate you, whichever report you're concerned about. If you didn't do anything wrong, the report will vindicate you. It will be an open and transparent report like others that just talks about what really happened, what should have happened, is there a discrepancy, and if there's a discrepancy, is it material enough to constitute improper conduct? And if so, what are we going to do about it? So please, good people, just calm down. Let's stop with the childish games. Then, going on to the report I am releasing today. As I've indicated, it is one of those Gogodlameni cases. However, it is a case that has systemic implications. The report deals with Eskom and one member of the public that qualifies to be referred to as a Gogodlameni. Mr. Brian Molife, who is the Eskom Group Chief Executive, said on the 21st of July 2016, I quote, "Being customer-centric ties in with the principle of Batubili, which enjoins us to put people first by improving our efficiency and accountability to the recipients of services that we provide." Close quotes. Who tempered is my report as the Power Protector, issued in terms of Section 182 of the Constitution of the Republic of South Africa, 1996, and Section 81 of the Power Protector Act, number 23 of 1994. The report communicates my findings and the remedial action I'm taking in terms of Section 182 1C of the Constitution, following an investigation into allegations of maladministration by the Western Cape Operating Unit of Eskom Holdings, a state-owned company, which hereinafter is referred to as Eskom. The report deals with alleged wrongful disconnection of electricity supply to the premises of Ms. S. Kumalo on 29 February 2016, improperly imposing a temporary and reconnection fee of 12,000 Rand against her, and generally improperly handling the matter involving a faulty prepaid meter and use of unpaid electricity. The complaint was lodged by Mr. Sean Kumalo on the 1st of March 2016 on behalf of his mother, Mrs. Simone Kumalo, whom I shall refer to as Mrs. Kumalo. Mrs. Kumalo is a 49-year-old homeowner residing in Bongweni, Kaelisha, and she is employed as a general worker at a bus company. Her home is fitted with a prepaid electricity meter located inside her house. This ordinarily enables Eskom to obtain revenue in advance for the supply of electricity, and it allows Mrs. Kumalo to use whatever amount of electricity she may have pre-purchased and loaded onto her account. The respondent is Eskom, a critical state-owned enterprise which is entrusted with the responsibility to ensure that the entire electrical energy needs of South Africa are met economically and efficiently. Its role includes indirect and direct sales of electricity and collection of revenue in respect thereof. At the inception of the investigation, Eskom was asked to fix and reconnect the prepaid meter pending the findings of the Pub Protector, but it refused to do so until the release of my provisional report in September 2016. The impact was that Mrs. Kumalo was unable to purchase prepaid electricity from the period of disconnection, which was 29 February 2016, until Eskom reconnected the electricity on 5 September 2016. The family was accordingly without the use of electricity at its residence for about 6 months. During the 6 months of inability to purchase prepaid electricity, Mrs. Kumalo relied on neighbors for some of the electricity needs of the family, using second industrial revolution energy mechanisms for household energy needs. The neighbors assisted Mrs. Kumalo with ironing their clothes and charging cell phones. For cooking, Mrs. Kumalo bought a gas stove and a paraffin heater to boil water. The investigation process commenced with an attempt at ADR, or alternative dispute resolution. Unfortunately, the person representing Eskom had not been given a mandate to settle, and the ADR did not achieve the requisite results. The conciliation process, though, did shed light on the factual circumstances that led to the complaint. During this process, Eskom conceded that it did disconnect electricity at Mrs. Kumalo's premises on 29 February 2016. Eskom further conceded that this happened 26 months after Mrs. Kumalo had reported a faulty meter to Eskom, advising that such faulty meter was preventing the family from loading prepaid electricity credit and instead allowing the family to use electricity without paying. Eskom further considered that a technician was sent to the premises of Mrs. Kumalo the same day when Eskom received the alert from the Kumalos. This was done without making prior access arrangements with the Kumalos. Eskom reported that the technician did not find anyone at Mrs. Kumalo's house, and that he was accordingly unable to fix the faulty meter. No further action was taken by Eskom until the follow-up visit on 26 February 2016. This was 26 months later. 3 days later, Eskom disconnected the prepaid electricity supply to Mrs. Kumalo. All parties did not dispute that after Eskom switched off the prepaid electricity at Mrs. Kumalo's residence, the matter was reported to NESA, which determined the tempering issue in favor of Eskom and the payment for used electricity in favor of Mrs. Kumalo. NESA placed a lot of emphasis on previous tempering and the fact that the box where the meter is housed was not sealed at the time the tempering determination was made. Regarding the payment of used electricity, NESA decided that it was Eskom's fault that such electricity was illegally consumed and unquantified. Eskom and NESA further submitted that the public protector has no jurisdiction on the matter, given the fact that NESA had duly dealt with it, and that if Mrs. Kumalo was not happy with NESA's determination, her only option was to approach a court of law. It is my considered view and finding that the argument that the Pub Protector has no jurisdiction is inconsistent with the provisions of Section 182 of the Constitution, which only excludes court decisions from the Pub Protector's remit. In my view, the Pub Protector is an alternative to the courts, providing people without means, such as Mrs. Kumalo, whom we fondly refer to as Gogo Dlaminis, with a viable alternative to the scrutiny of actions of state functions. In my view, the Pub Protector is an alternative to the courts, providing people without means, such as Mrs. Kumalo, whom we fondly refer to as Gogo Dlaminis, with a viable alternative for the scrutiny of actions of state functionaries and righting of administrative roles experienced through the conduct of state functionaries. The NESA Act, which precedes the Constitution, cannot trump the Constitution in this regard. I accordingly proceeded to review the acts of both Eskom and NESA on the understanding that the Pub Protector does have power to review the conduct of state functionaries operating under the auspices of these institutions. The matter for my determination centered on Eskom's conduct regarding the determination of the cause of the malfunction of the prepaid meter, leading to consumption of electricity without pay or quantification, imposing of a temporary fine and termination of access to prepaid electricity. Eskom submitted that the meter had been tempered by the complainant, hence the imposition of a temper fee, and in this regard cited the findings of the National Energy Regulator of South Africa, that is NESA. The complainant insisted that the family never tempered with the prepaid meter, that the box had not been changed by Eskom after fixing the damage caused in the previous tempering, and that had it tempered as alleged, it would not have reported the faulty meter, and advised Eskom that such meter was preventing the family from loading electricity credits while allowing it to use unpaid electricity. Just to clarify, the report does not dispute that the Kumalos had previously tampered with the electricity meter. It also does not dispute that the Kumalos had no right to free electricity. It also does not dispute that Eskom has the power and responsibility to make sure that people do not use electricity illegally. The issue at hand is whether or not the process followed by Eskom and later NESA was proper, or if that process constitutes maladministration. If the process constitutes maladministration, can we then say somebody was prejudiced by that process? On analysis of the complaint, the following issues were considered and investigated. Did Eskom wrongfully disconnect the electricity supply to Mrs. Kumalo's premises? Did Eskom improperly impose a tempering and reconnection fee on Mrs. Kumalo? Did Eskom improperly handle the alleged prepaid electricity meter malfunction matter? And did its conduct amount to maladministration? Was the complainant's mother or any other person prejudiced by the conduct of Eskom? And if so, what would it take to place the persons where they would have been had Eskom acted properly? The investigation process included the exchange of correspondence with relevant parties, meetings and interviews with the complainant and officials of Eskom and their service operating agents. There was also an inspection in loco. After the initial investigation, Section 7(9) notices were saved on Eskom and NESA. A Section 7(9) notice is a notice alerting a party to evidence implicating that party and giving that party an opportunity to refute that evidence before a final determination can be made. Having determined on a balance of probabilities what happened, I contrasted the conduct of Eskom in this matter with the conduct that was required of Eskom in terms of the laws and other prescripts that regulate its conduct. The key laws and prescripts that informed my evaluation of Eskom's conduct were primarily those regulating the delivery of prepaid electricity, principles of administrative justice as envisaged in Section 33 of the Constitution, and the Promotion of Administrative Justice Act. I also took into account general principles of public administration as envisaged in Section 195 of the Constitution. In this regard, the conduct of Eskom relating to the alleged wrongful disconnection and imposition of a tempering and reconnection fee had to be in line with Section 33 of the Constitution, which incorporates a principle referred to as the alterum partem principle, that is, the right to be given an opportunity to speak in your defense before a decision that adversely affects you is made. I also took into account Eskom's conduct, and that such conduct should have been in line with Section 195 of the Constitution, which requires that certain basic standards of public administration, such as accountability and transparency, should be adhered to by all state functionaries. In this regard, I was also guided by the Constitutional Court's pronouncement in Kumalo versus MEC for education. This is a 2013 case of the Constitutional Court, where the Constitutional Court said that a state functionary who is alerted to an irregularity or impending irregularity has a responsibility to take action to arrest such irregularity. In view of the matter being about the alleged tampering with the electrical apparatus and or interference with the supply, I also took into account the Revenue Protection Act and regulations under it. The Act stipulates a due process that should be followed before adjudicating such matters. In the light of the regulatory powers of NESA, I also took into account NRS 0471 of 2002, which is on electricity supply, quality of service. This provides guidelines in respect of the procedure Eskom should have followed before disconnecting the electricity supply to Mrs. Kumalo's home. In addition to these regulatory instruments, I also took into account considerations of reasonableness, rationality, and fairness regarding the conduct of both Eskom and the complainant's mother throughout the process, from the moment the allegedly faulty prepaid meter was reported to the date on which Eskom disconnected the electricity supply. I'm grateful for the cooperation rendered by the General Manager of Eskom in the Western Cape, Mr. A. Lester, and the Eskom Group Chief Executive Officer, Mr. Brian Mulife, for the steps taken to remedy problems identified at the commencement of the investigation, and for ultimately reconnecting the electricity supply at Mrs. Kumalo's home on receipt of my provisional report. After examination of all of the evidence, I have reached the following findings. The first finding is regarding whether Eskom wrongfully disconnected the electricity supply, regarding whether Eskom wrongfully disconnected the electricity supply to Mrs. Kumalo's premises. I find that the allegation is substantiated. I have provided reasons in the report, but basically the reasons are that the process followed was not fair, that she wasn't given an opportunity to present a defense in her favor, and that too much weight was attached to the fact that she had previously tempered and admitted to tempering. And Eskom did not take into account the fact that she is the one who reported the faulty meter. And secondly, that in her evidence, she said that the box was not sealed after the original tempering was fixed. I also took into account that Eskom waited for 26 months before it went back to Mrs. Kumalo's home. After she reported the matter, Eskom sent a technician, or so it says, who went there without making a prior access arrangement, and on not finding the family, went back and reported that he had not fixed the meter because he had not had access. But for 26 months, nothing was done until Mrs. Kumalo applied for a second box to have electricity services at her house. When Eskom went to install the second box, it discovered that the family was consuming electricity without paying, and then proceeded to hold the family accountable for tampering with the meter. My determination is that Eskom's conduct regarding the handling of the process was in violation of Section 33 of the Constitution and Section 195, and that conduct accordingly constitutes maladministration as envisaged in Section 6 of the Public Protector Act and 182 of the Constitution. Regarding whether Eskom improperly imposed a tempering and reconnection fee on Mrs. Kumalo, I find that that allegation is substantiated again. Because if the process of determining whether or not the meter was tempered by Mrs. Kumalo was faulty, a decision to say that she must pay for the tempering was also faulty. Again, my decision is based on a violation of PAJA in Section 33 of the Constitution, as well as Section 195 of the Constitution. And I find that the conduct constitutes maladministration and improper conduct. Regarding the general handling of this matter by Eskom, the allegation that Eskom improperly handled the matter is substantiated. For 26 months, Eskom failed to fix a reported prepaid meter malfunction, having been duly warned by Mrs. Kumalo that this was allowing unauthorized free use of electricity that should have been prepaid. This also resulted in unaccounted for consumption of available electricity at a time when electricity consumption planning has to become critical to prevent load shedding. Eskom's argument for imposing a tempering fine underscores the importance of preventing illegal connections and loss of revenue, which it claims to lose billions to. It is accordingly unclear how this anomalous situation was allowed to drag for this long, with loss of revenue in the process. 26 months of uncollected revenue is tantamount to a dereliction of duty on the part of Eskom, in violation of Section 195 of the Constitution and Section 51 of the Public Finance Management Act. It also is inconsistent with Eskom's financial stewardship responsibilities. I find Eskom's conduct in failure to collect revenue for 26 months to be clearly inconsistent with its statutory responsibilities. The conduct therefore constitutes maladministration in terms of Section 6 of the Public Protection Act and improper conduct in terms of Section 182 of the Constitution. Regarding whether Mrs. Kumalo and other persons were improperly prejudiced by Eskom's conduct, I find that Mrs. Kumalo and her family were prejudiced by Eskom's conduct. Due to Eskom's failure to timely attend to the report regarding a malfunctioning prepaid meter and ensure the family had a functioning meter and did not consume electricity that is not quantified without paying for it, and uncertainty was perpetuated. And Eskom eventually prevented the family from lawfully buying and using electricity, a situation that persisted for 6 months. The outcome resulted in the family's inability to use convenient and clean energy in violation of Section 185 of the Constitution, requiring members to be informed in a timely manner about the disconnection of services. It can also be said that Eskom's conduct was at odds with Sustainable Development Goal number 7, requiring access to affordable, reliable, sustainable, and modern energy for all, the impact of which is to undermine environmental policies. Needless to say that those that pay for electricity may have been prejudiced by the offsetting of the unpaid electricity against their accounts. Regarding what it would take to place Mrs. Kumalo where she would have been had Eskom acted properly. In view of Mrs. Kumalo's knowingly consuming unpaid electricity for 2 years, knowing she was not entitled to free electricity, and without taking reasonable steps to mitigate her circumstances by following up or ensuring a follow-up on Eskom, I'm unable, with good conscience, to lay the blame entirely on Eskom or treat Mrs. Kumalo and her family as helpless victims of Eskom's dereliction of duty or improper conduct. Generally, my finding is that she did consume electricity that did not belong to her, and she had an opportunity to remind Eskom that the problem persisted. The remedial action I am taking in pursuit of Section 182(1)(c) of the Constitution is the following. Eskom, the General Manager of Eskom Western Cape, is to ensure that the tempering fee on Mrs. Kumalo's account is reversed, as such was imposed without following due process. 2, ensure that Mrs. Kumalo's liability with regard to the consumption of electricity without paying for it from 4 September 2013 to 29 January 2016 is calculated and reasonable terms are agreed to with her for the payment of the debt. 3, ensure that a mechanism is put in place to alert Eskom of similar incidents where electricity is being supplied without necessary payment being rendered, and to take the necessary remedial action in that regard. 4, revise the standard operating protocol to ensure that each incident of reported faulty or illicit consumption of electricity is conclusively resolved, and that disciplinary action is taken in future against technicians who abandon a reported incident or faulty meter without certifying that such problem has been resolved. Regarding NESA, the remedial action is that NESA is to appoint an independent person to determine a fair value to be paid by Mrs. Kumalo for tempering and redo the investigation process properly, considering that the initial process followed by NESA was flawed. Basically, NESA has decided that the family should not pay for the electricity because it was Eskom's fault that the family consumed electricity wrongly. But since everything that NESA was done has been found in this report to be proper because of the procedure followed, that means even the benefit extended to the family, that the family should get free electricity, falls away. The decision, therefore, is that the family should pay for the electricity, but should pay fair value for that electricity. Thank you.
Thank you, Public Protector. We have now come to the Q&A session, and I need a colleague to assist me with a roving mic. There he is at the back. Right. We will take the first round of questions and we will start. Do you have a roving mic? Okay. We will start with you in front and we'll take the first two questions. Thank you. Question and action should
Afternoon, Advocate Madonsela. It's Team Nicholas Barr from the NCA. Advocate Madonsela, why have you chosen to invite us to a press conference to release this specific report? Would you agree that this may have some strong political connotations, especially to your detract? And what is your response to assertions that your support of Israel is essentially discounting the pain and suffering of the people of Palestine? You mentioned that you might be taking action against those who allege that you and your team are a stooge of white monopoly capital and a CIA agent. Can you confirm if this is the case? And then lastly, will you be releasing a provisional report into state capture? And what assurances do you have that your successor will continue the investigation into its finality? And I beg your pardon, and if Thuli Madonsela is reinstated as SABC COO, do you intend to take the matter further, and if so, how? Thank you.
There's so many questions. Can I just respond to them this way?
Nicholas asked many questions, and the Secretary would like to respond before you go to the next one.
Thank you. I thought because you gave us 5 questions, which is 5 people's questions, I might as well respond to you, Sam. Regarding Eskom, I hope Eskom does not take this political. In the report, I have acknowledged the assistance that was provided by the Chief Executive Officer of Eskom and the head of Western Cape. It's just an issue of an anomaly that I think Eskom needs to pay attention to. The reason we chose the report is twofold. One is it's one that we were 100% sure that we've consulted all of the parties. We've received all of the comments on our Section 79 notices, and we believe we're now on firm ground to release the report. That was the first part. The second part is that although it's a small Gogodlamini matter, it has systemic implications regarding how Eskom follows up on alleged tampering or on alleged theft of electricity, which then affects the power supply or the planning of the power supply, because if you can't account for how many people are using electricity at any given time, then your planning of electricity supply is going to be affected. And it is in that spirit that we issue the report to advise Eskom accordingly. We haven't received any negative vibes from Eskom. Like most other organs of state, Eskom defended its actions. However, I believe that the decision I've made is justified in the circumstances. The question regarding Israel, can I just have a confirmation again? Or what is the question?
I'm just picking up a reaction to what you said earlier in the press conference, Advocate.
Yes.
People such as the BDS groups assert that your support or at least neutrality towards Israel discounts the pain and suffering of the occupied people of Palestine.
Well, that's their opinion, and I disagree with them. I may disagree with some of the things that, let's say, the Botswana government does. For example, I don't agree with the death penalty in Botswana, but I have been to Botswana, and I have applauded the actions of the Botswana government on the things that the government does right. But my opinion on the death penalty is my personal opinion, and it's not fair to impose it on anyone else. I'm just using Botswana as an example. I could choose any country about things that I may not disagree with and things that I agree with. I do want to state categorically that I have no animosity towards Israel or any country. I do believe in a two-state solution between Israel and Palestine. I do believe that both the people of Israel and the people of Palestine deserve a decent life. They deserve to have their statehood acknowledged. They deserve to have their human rights and humanitarian law protected. If these people were really interested in my views on this matter, I have given various speeches on this matter, including on just issues of observance of what I refer to as humanitarian law. You may want to check my speech, which was given at the Institute for Cultural Diplomacy in Germany last year, where I dealt with these issues. People who are attacking for the convenience of attacking, to be fair, I don't think this thing has anything to do with Israel. I said so when somebody from the South African Jewish Board of Deputies approached me to apologize about dragging me to this. And my response to Mary Klug was, I'm the one who was apologizing to you because you're being hit in the crossfire. I believe this has nothing to do with Israel. I think this is just an attack that is being unleashed on me in this office. Regarding the CIA, I just believe that that particular issue is people, grown-ups behaving like children and just playing a game. And I've decided I really don't want to engage in that game. I really don't have the time. Right now, I will not deal with it. I will not do anything about it. I have said, as I said on ENCA this afternoon, if they want to play this game after the 15th, since I'll have a lot of time in my hands, I might just take them up on that game. But for now, I really have a job to do, and I'm not going to play these childish games. So for now, they can play as much as they want. I will not attend to that. But after the 15th of October, I may just play the game. On state capture, we are, as I've indicated earlier, doing our best to conclude this investigation and many others. We have anticipated that there will be leftovers, as there may be in some of the other investigations. The report we will issue will indicate what has been concluded and will indicate what will be outstanding. This we did with the PRASA report, where we indicated where we have conclusive evidence and we indicated where the matter needs to be taken.
Well, coming out of that press briefing by outgoing Public Protector Thuli Madonsela, just wrapping up her final reports, really is a race against time as she...
Proceeding with this investigation. Regarding Mr. Hlaudi Motsoeneng, I have indicated that to the Minister that it would be improper to appoint Mr. Motsoeneng to the position of acting COO. If the court's view is that he's unfit to be a permanent COO, it doesn't make sense to assume that the court is saying he is fit to be an acting COO. Given the reason the court said he was unfit to be a permanent permanent COO was the finding that I made as a public protector that he's a dishonest person. I have indicated to the Minister in writing that should should she or the board proceed with this matter, we will take this matter to court. We'll give instructions to our lawyers to sue both the minister and the board, and we'll ask for costs from them as individuals. Because that's not just disrespect for the public protector, it is disrespect for the courts in this country, and it is our duty as a public protector South Africa to protect the rule of law and to ensure good governance in this country. Thank you.
From the Mainland Guardian. Ma'am, you seem to be laying out a case for contempt in terms of your Empowering Act. You're talking about people who are trying to undermine your office, trying to undermine investigations that are currently ongoing. The previous instance that you described as such, you declined to initiate action based on contempt, saying that your investigation had already been concluded. To put it pointedly, are you thinking about contempt proceedings in this instance, finally pushing that button? And if not, the same question we asked at the time of Nkandla, at what point are you undermining your own office by declining to take that action? If I can throw in a second one, do you have an update for us on the criminal investigation around the invasion of your offices recently? Has SABC been in touch on that?
Thank you. We will allow the public protector to respond.
Thank you. No, I'm not laying ground, Mr. DeVert, for contempt proceedings. Right now, my team and I have a job to do, which is to conclude the investigations we can conclude. Any distraction to start contempt proceedings, to sue people, would really be wasting our time. And in a way, it might be really falling into that trap where we are supposed to distract ourselves and start doing things that we shouldn't be doing. I will not do anything on contempt. The public, on the other hand, may institute contempt proceedings because the public protector protects the public, and the public can protect the public protector as an institution, not as a person. Because you correctly are saying that if there is contempt of the public protector, it's an institutional damage. It's not about the person. But for me personally, I consider this a joke, and the people who are doing this, I consider them childish. And I am not going to play any childish games with them. But since after finishing office, then I might have time. Who knows, I might decide to be childish too. Thank you.
For the Times newspaper. Advocate, you have been quoted as saying you were considering taking legal actions against Colin Maine. Could you please bring us to speed with this regard? Have you consulted and what was the advice?
Thank you, Mr. Mabena. I did consult my head and decided no, that would be playing childish games with people, and I have no intention to play those games. But the answer that I've just given to Mr. DeVert applies to you, sir, that should such childish games be played after the 15th of October, or from the 15th of October, who knows, I might just have a lot of time in my hands and might decide to join them in those childish games.
Are there more questions from the floor? Okay, I've noticed you. Is there any other? All right, it will be you.
Yes, we will take a final round of questions. The last two questions for this session. Thank you.
Chair Thuli Madonsela from ANN7. I understand that in terms of the state capture, there were issues of funding, and then funding was made available. We know also that you did mention that the number of Dominican priests were ones that brought the matter up, and then a member of government came up, and due to the Members Ethics Act, you needed to act on it. But why necessarily that family? And you haven't concluded the case, so what is left in terms of interviews or probing that needs to happen in order to conclude?
Sorry, ma'am. Can I just get the first, the surname? Name and surname? Majani.
S-A-T-J-A-N-E.
Thank you. I take it that the question is, why did we request the additional resources?
And what else needs to happen?
Yes. We requested the additional resources because it was a must case in terms of the Executive Members Ethics Act, and our hands were already full. That was my letter to government, was I am required by law to conduct this investigation, and my hands are already full. And I indicated to government that going forward, we need to pick up some of these investigations and treat them as a commission of inquiry and give them resources. Instead of saying we want additional funding for the public protector to be considered, rather have a case-by-case funding. And we've seen that working in this matter, and we've seen it working when we've assigned additional resources. I'm not in a position to indicate at the moment how much more work still needs to be done. I can just confirm that we've conducted extensive interviews with key witnesses whose names have been in the media, and that we may have to interview further witnesses, because sometimes when you've identified a list of witnesses, those witnesses identify further people that you may have to meet. And because of that, your witness list keeps extending. That's what happened with the CX report. We had identified specific witnesses when we started, we interviewed them. But with some of them, as you interviewed them, they kept giving us additional people that needed to be spoken to. And because we're required by law and just the principles of good investigations to look for the truth wherever it appears to be hiding, we have to then extend these interviews to this additional list of witnesses.
Yes.
Buntu Williams from ANN7. Just one from me, really. Just noticed, and I'm sure quite a few people have, that the NC Youth League has of late been consistent in its tune that you might be linked to the DA, and that you never investigate anything that's not to do with the ANC, and that you seem biased against the ruling party, specifically judging by the sort of cases that we've looked at, maybe because some of those high-profile individuals tend to be members of the ruling party. But, you know, there have been these allegations. What do you say to that? And plus, you know, over the weekend that the leader of the opposition was mentioning things around the update you gave him regarding the state capture investigation, for instance. So that might just have added fire. But I wonder what would be your response to this seemingly consistent link to the official opposition party.
Thank you, Mr. Williams. You are a seasoned journalist, and it's good to see you after many years. And as a seasoned journalist, you know that the governing party of this country is the ANC. The governing party of the Western Cape is the DA. And of course, the governing party of some of the municipalities has changed in the last election. Your intake of cases is determined by who's governing. Would you agree with me? That any national investigation will only involve the ANC. So that doesn't take rocket science to deal with that. All national investigations will involve people who are, if there are politicians involved, there will be ANC. If they are officials, it would be neutral. They would just be the people who are appointing government. So people who are persistently peddling that lie should just look at that and say, what would you be investigating the DA for in national investigations? For being the opposition in parliament? It just doesn't make sense. But regarding where the DA is governing in the Western Cape, just check our statistics in the annual report, because the truth speaks for itself. The lies are pretentious, but the truth is in the report. And look at our annual report and look at our stats for the Western Cape. Look at our reported reports and look at how often do we report from the Western Cape. In fact, this also comes from the Western Cape. I don't know whether the Eskom guy in charge of the Western Cape is ANC or DA. I suppose the governing part or whoever is my accuser knows what I don't know. I don't know if Mr. Molife is ANC or DA. I just assumed that they are state officials, and here we're releasing this report from our Western Cape team, and some of the reports that will become. So say these accusations are patently faulty, but you also just don't understand what is the intention. What I can only conclude say is that the people who are peddling that are just trying to delegitimize the voice of this office. And why are they trying to delegitimize this voice of this office? Do they have anything to hide? I don't know. What I said to people here, and I'm honest about that, is that if you have done nothing wrong, you have absolutely no reason to worry. We will continue to have these transparent processes. We will continue to have transparent reports, and it will be very clear where we found our information, how we evaluated it, and how we arrived at that conclusion. That's always been the case in all of our reports. We're not about to change that modus operandi in 14 days' time. That I reported back to the Honorable Maimane is also something that shouldn't baffle anyone. It is standard practice that if you have lodged an investigation with this office and you request an update on it, we give you that update. In fact, with these people that became interested belatedly in the CX report, we gave them an update even though they were not even complainants. Are we affiliated to them? No, sir, we're not. So for you as a seasoned journalist, sir, I'm saying when people are making ridiculous allegations, I'm asking the media to evaluate those allegations before we give them the legitimacy they're trying to get for themselves. Because this office is an important constitutional institution. Serious men and women work to produce these reports. As investigators, they work with me more or less like a judge. They investigate, although I supervise, but they have to defend their position before I decide I agree with them. And you should have seen me, yesterday, and I sat with the team and I was saying, this, that, and this. No, but you can't do that. This is how we would like things to go. This is how this team works. And when people are insulting me, they must know that they're not insulting me. They're insulting these men and women who work hard to find the truth wherever it's hiding and tell it the best they know how, and then have to defend their findings to me. And ultimately, when I accept those findings, it is when I'm convinced that we have searched for the truth in the right places, we have found it, and we have told it the best we know how, and that truth has been contrasted with the law and other rules that regulate the conduct we are called upon to judge. Thank you.
Good, my name is Lila from SABC Radio News. And that It was just announced, like Mr. Thuli Madonsela has been appointed as the Group Executive Corporate Affairs. I would like to know, you said that you take legal action if he was appointed at the COO again, or are you still going to take legal action, or is that now done?
Thank you. Well, the starting point will be to find out what was the process of appointing him. Was that position vacant? What was the position's requirements before he was appointed to it? Because that position would have been advertised before the previous incumbent was appointed. What were the requirements? And what process was used to determine that Mr. Motsoeneng is now fit? Firstly, to be an executive in the SABC, and secondly, to be fit for that specific position. Once we have given them the RD and we received the response, we're going to evaluate that response, and if the response is inadequate, we are then going to take action. And yes, that action will include instructing an attorney to take action against the SABC board. That I did say to the Minister of Communications. I did say that if Mr. Motsoeneng is appointed as acting COO or another senior executive position at the SABC, it would be a violation of the spirit of that judgment.
Thank you very much. Are there more questions? All right, we will take the last two and we will give you the opportunity for one-on-one interviews afterwards.
Thank you. Thuli Madonsela from Power FM. You come into contact with a lot of cases where there is alleged maladministration and corruption. Do you think if all these cases had to add up, there would be a possibility that the country could afford free higher education? Thank you.
Okay. Yes, ma'am. If we do clean up maladministration, which includes wasteful expenditure and corruption, we can fund free education. However, that's not something we can just snap a finger today and say we'll claw back the money from maladministration and corruption and putting it into education. It is going to be a process, but yes, I've said that before.
From the Motor Guide again, ma'am. Just to remind you of that question, the invasion of your offices not that long ago, has the South African Police Service been in touch with you? Have you been kept up to date on the investigation around that investigation? And then I would very much like the invasion of your offices, the incident during which people stormed past security and took up residence in some of these offices. And the second question, I'm sure that you know the governing legislation really well. Is the President required to accept the name suggested as your successor by or before the 15th of October? And if your post is not filled, what happens constitutionally? Is there a process to compel the President to put someone in your chair?
Thank you. Regarding the invasion of my office, the CEO was just reminding me which one was it. I wasn't here, the team was here. I don't know if the CEO has heard from the police. We haven't heard from the police yet. Regarding the appointment of my successor, if the Public Protector is unable to do his or her work, the Deputy Public Protector becomes the acting Public Protector. About compelling the President to appoint someone in my position, I'm not aware of any provision, but I would think that, like any other executive action, people can petition the president, people can go to court and request the mandamus or something like that. But I must say that although the president is just the administrative authority in this case, it is expected that he has to apply his mind.
Thank you. We will now do one-on-one interviews with the public protector.
Thank you.
How much time before you have to go? How much time before you have to go?
Can I write it here and then you're going to take a shot of it?
Just give us 10 minutes.
Tell me if there's any arrangement of time. Thank you, Otis. Mistakes there on the card. Have they edited it? Okay, maybe give them the report. Have they edited it properly? They hadn't edited it before they gave it to you. Well, I don't like political because I like politics.
We say ekhona eyelona. Okay, ekhona eyelona itorloatsa. Keep kupile ba fokotse before the crossing because it was affecting the sound as well.
You should have missiles.
I was live, so I couldn't.
The last question about the question that Lila asked about Saudi.
Let me just check. No, I've got it the first time because it was repeated. It was, remember the
way she put the last one was not repeated.
Yeah, no, it was. I didn't get it.
Should we get that?
I didn't get it. Yeah, you can. Yeah, we're going to do it.
You already have. Yeah. Okay. The last part where she left on the point. And then the other thing. Can we please have Kumalo's address? We do ask the complainants if they
just so I could
will ask We'd like to send the South, the Cape Town team, so that we can have the story ready for tonight. Let me ask you.
Should I call? Let me connect the microphone.
Are you ready? Yeah.
Almost.
You will find